Alex here with part 163 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version, as the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into my attorney's reply to opposition to my ex's. You know what? Let's just lump this into the category of we are trying to argue as to why we should be allowed to execute on the judgment that the court gave me for those medical arrearages, child support arrearages, and also why she should be subjected to a debtor's exam. The reason I say that is because there are about 6 different documents being filed by both my ex and my ex's attorney and my attorney. And those documents, though they have different names and they have slightly different angles, they're basically the same. And that's what I'm about to lead into right now, which is that this document will have pretty similar arguments to what we had in our opposition to motion to strike. So as I go through this document, I'm going to skip over those portions of the document that are, for the most part, just a copy paste. If I see anything different in this document, then of course I'll go ahead and address that, similar to what happened when I noticed arguments with regards to whether or not it was appropriate for my attorney not to sign the writ of execution. That was one of the new arguments that we went over in the last video, and turned out that those are not signed by attorneys anyway. So same thing, guys. If there is a new argument in this document, I will stop and take a look at it. But this may be a very short video because I have a suspicion that most of these citations and arguments are going to be just copy pasted from the previous documents that were filed. For the most part, if you guys haven't, fully got your head around what's going on, is 6 different briefs, but really it's just 2 different positions. So even though there's 6 briefs, it's just 2 positions. Position 1 is I am a bad person for trying to execute on my ex's judgment, as well as trying to get her subjected to a debtor's exam, and therefore I should be punished for that. And then my argument, which is she hasn't paid anything. She's offering just $50, even though she owes like $600, and that's just for this month alone. We're not even counting the multiple thousands of dollars that the judge entered into the judgment. So her position is I'm being ridiculous, and my position is she's being ridiculous. And let's just go ahead and go straight into what my attorney has filed. Here we have my attorney's reply to opposition to motion for supplementary proceeding in the aid of execution. Standard introductory paragraph introduces me to the court. My attorney is indicating that she's representing me and that we are filing a reply to our ex's opposition to motion for supplementary proceeding. Okay, so first we have the argument on her failure to service under the rules of civil procedure. This is one of the arguments that's just copy pasted, so we'll continue through it. Nothing new here at all. Next we have the, motion for supplementary proceeding in the aid of execution. It must be granted as, okay, this is new. I think this is new. I'm not sure. It might have been in my initial motion, but let's just go ahead and go through it. So why are we allowed to even conduct a supplementary proceeding, or what is more, informally known as a debtor's exam? And the answer to that question is the law says so. NRS 21.270 subsection 1 is the statute that says a judgment creditor at any time after the judgment is entered in bold is entitled to an order from the judge, blah, blah, blah. So all I need to be is a judgment creditor. All I need is the judgment having been entered. That's it. There's nothing more, nothing less. And in fact, this is what the Court of Appeals cites in its order as a basis for finding that my judge has abused her discretion in ruling against me. They will cite this specific statute with this specific subsection. I want to let you guys know, had I not cited this, would I have won the appeal? The answer to that question is no. I have to preserve these arguments if I am going to prevail on appeal. If you do not do this, you will lose your appeal 100% for sure in Nevada. It's not like they're just going to go ahead and find the statute for you and ding your judge for it. You have to find the statute yourself. You have to tell the judge about it yourself. And the Court of Appeals is there to say, you know what? They told you what the law was and you did not apply it correctly. They're not there to say, hey, we expect you to know all of the millions of statutes. No, it's an impossible approach to how appellate courts would work given their limited resources and the fact that there's only 7 of them. Actually, for the Court of Appeals, there's only 3. Anyway, let's go ahead and move into the next section. The language of the statute does not provide the court for court discretion. If you guys want to know more about what this is, please watch my video on the topic discretion. What I am telling the judge here is that she doesn't have any discretion. The language of the statute is plain, and it tells her what she's supposed to do. And the judge's response is, I don't care about the law. I'm not going to do it. So that's why we have, courts of appeals, appellate courts, and Supreme Courts to deal with judges like this who won't apply the law, despite the law's language being plain and having no room for interpretation. Next, we have citation to Levin v. Frey, where the Supreme Court has stated that generally, when a statute's language is plain and its meaning is clear, the courts will apply that plain language. Period. That's not that complicated. Here, the language is clear. A judgment creditor is entitled to an order for a judgment for a debtor's exam. The language does not leave room for discretion. It doesn't. The Court of Appeals will tell her this. Next paragraph here is that my ex's arguments that, quote, the primary purpose of NRS 21.270 subsection 1 is to permit a party who has been awarded a money judgment to question the debtor about his or her assets in order to determine how the judgment may be satisfied, unquote. And that, quote, after holding an evidentiary hearing in this matter, the court determined that the judgments should be satisfied by my ex paying $50 per month until they are satisfied, unquote, fail for several reasons. And I go into why these arguments fail here. My ex's arguments are nothing more than policy arguments regarding the practical effects of the statute and the court's ruling on the administration of the legal process. I tell people why you can't do this. There's a video where I talk about policy versus the law. The Supreme Court of Nevada has addressed this issue and found that, quote, unfortunately, policy arguments are unavailing in the face of an unambiguous controlling statute, as we have here. We must assume that the legislature, when it enacted the statute, was aware of the various policy considerations and purposefully drafted the statute to read as it does, unquote. This is obvious. The place for debate is before the legislature. It's not in the courtroom. It's not. And so what the attorney is trying to do here is flat wrong. And he successfully induces this judge into committing legal error. She falls for his nonsense. Anyway, let's continue. Here, the statute is unambiguous, and as such, this court must follow the language of the statute, despite any policy arguments to the contrary. Hopefully this makes sense to you guys. We have different sections of government. We have a place where laws are created. We have a place where laws are interpreted. And we have a place where laws are enforced. You're not supposed to mix these all up. There are rare exceptions for when this is okay. But for the most part, under the circumstances of this specific issue, the law is clear. So none of those exceptions apply. When the people who made the law made it clear, the people who interpret the law are required to interpret the law as they made it. They're not allowed to say, well, hold on, let's do an extension of the legislative session and let's go ahead and debate all these various different policy considerations because the legislature probably got it wrong. And so since they got it wrong, we're going to go ahead and interpret the law a completely different way than the way that they fashioned the law. That's basically what my ex's lawyer said. And the judge just ate it up. She just fell for it. Hook, line, and sinker. And it's going to cost her in this case, not once, but twice. She's going to get reversed twice over the same issue. Anyway, let's go ahead and continue. The rest of this is basically me arguing as to why there's nothing wrong with what I'm doing. She owes $50. She hasn't paid $50. In fact, that's just the arrearages. We're not even talking about the child support, which is another $500 some plus dollars. Next section here. This whole thing here is going into why none of what I am doing is unreasonable. I mean, I spend 2 full pages on this when I don't even need to. The plain language of the statute controls. I don't need to explain myself, but I go ahead and do it anyway, just so that the judge can see that I actually care enough to explain myself. And the judge doesn't care. She ignores all this anyway and sanctions me. So, I mean, you can bend over backward to try to explain yourself to a judge, and they just don't care. The only way for me to have controlled this outcome was to use the law. As crazy as it sounds to a lot of people think that the law is the friend of the lawyer and that we, the regular people, need the mercy of the court. But when you ask the court for mercy, they could care less. The only thing that works was the law. And you guys are going to find that out. I mean, you can read through those last 2 pages, me trying to explain myself and how it doesn't work. And when we go to the Court of Appeals, they don't talk about any of that stuff. They talk about that one statute. And using that one statute, they reverse all of the damage that this judge has done to our case. Anyway, respondent is not entitled to attorney fees. So here I go into the arguments that I have discussed multiple times in the series. And if you want to get sort of a better discussion on this, I would say take a look at the video, Defend Against Attorney Fees. And I know that this is also a copy-paste argument because we've talked about this in this particular briefing as well. So I'm going to move through it. Conclusion. For these reasons, I respectfully request that the motion for supplementary proceeding be granted and that my ex's request for attorney fees be denied. We have an affirmation under NRS 239B, which just indicates that this document doesn't contain a social security number. We have this certificate of Rule 5 service indicating that this document was served upon my ex's attorney. We have the motion opposition notice with the checkboxes indicating that this was a free filing. We have a couple of exhibits, which I think we already went through. Let's check them very quickly, though. Yeah, this is where she's asking to be served. So it's the same email. And this is, okay, so we've gone through these emails already. Here we have a request for submission, submitting to the court the issue as to the supplementary proceeding, the debtor's exam. And if you guys want to know more about the request for submission, please watch the video on the topic request for submission. I know we've gone over it several times in the My Docket series. Next page is a certificate of Rule 5 service indicating that this document was also served upon my ex's attorney. Going into the aftermath, I filed one document. It was a free filing, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't, or I did have an attorney, but she didn't charge me, so I incurred $0 in attorney fees. My ex's attorney would have probably spent just 15 minutes going through this document because she doesn't have to do anything. It's a reply. And most of the arguments are the same anyway. So I think 15 minutes at a rate of $250 an hour, it's going to come to $62.50 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.